Rule 86, Claims Against the State, Section 1. Notice to creditors to be issued by court. Immediately after granting letters testamentary or of administration, the court shall issue a notice requiring all persons having money claims against the decedent to file them in the office of the clerk of said court. Rule 86, Section 2. Time within claim shall be filed. In the notice provided in the preceding section, the court shall state the time for the filing of claims against the estate, which shall not be more than 12 nor less than 6 months after the date of the first publication of the notice. However, at any time before an order of distribution is entered, on application of a creditor who has failed to file his claim within the time previously limited, the court may, for cause shown and on such terms as are equitable, allow such claim to be filed within a time not exceeding 1 month. Rule 86, Section 3. Publication of notice to creditors. Every executor or administrator shall, immediately after notice to creditors is issued, cause the same to be published 3 weeks successively in a newspaper of general circulation in the province, and to be posted for the same period in 4 public places in the province, and in 2 public places in the municipality where the decedent last resided. Rule 86, Section 4. Filing copy of printed notice. Within 10 days after the notice has been published and posted in accordance with the preceding section, the executor or administrator shall file or cause to be filed in the court a printed copy of the notice, accompanied with an affidavit setting forth the dates of the first and last publication thereof, and the name of the newspaper in which the same is printed. Rule 86, Section 5. Claims which must be filed under the notice, if not filed, barred. Exceptions. All claims for money against the decedent arising from contract express or implied, whether the same be due, not due, or contingent, all claims for funeral expenses and expenses for the last sickness of the decedent, and judgment for money against the decedent must be filed within the time limited in the notice. Otherwise, they are barred forever, except that they may be set forth as counterclaims in any action that the executor or administrator may bring against the claimants. Where an executor or administrator commences an action or prosecutes an action already commenced by the deceased in his lifetime, the debtor may set forth by answer the claims he has against the decedent, instead of presenting them independently to the court, as herein provided, and mutual claims may be set off against each other in such action. And if final judgment is rendered in favor of the defendant, the amount so determined shall be considered the true balance against the estate, as though the claim had been presented directly before the court in the administration proceedings. Claims not yet due or contingent may be approved at their present value. Rule 86, Section 6. Solidary obligation of decedent. Where the obligation of the decedent is solidary with another debtor, the claim shall be filed against the decedent as if he were the only debtor, without prejudice to the right of the estate to recover contribution from the other debtor. In a joint obligation of the decedent, the claim shall be confined to the portion belonging to him. Rule 86, Section 7. Mortgage debt due from estate. A creditor holding a claim against the decedent secured by mortgage or other collateral security may abandon the security and prosecute his claim in the manner provided in this rule and share in the general distribution of the assets of the estate. Or he may foreclose his mortgage or realize upon his security by action in court, making the executor or administrator a party defendant. And if there is a judgment for a deficiency after the sale of the mortgage premises or the property pledged in the foreclosure or other proceedings to realize upon the security, he may claim his deficiency judgment in the manner provided in the preceding section. Or he may rely upon his mortgage or other security alone and foreclose the same at any time within the period of the statute of limitations. And in that event, he shall not be admitted as a creditor and shall receive no share in the distribution of the other assets of the estate. But nothing herein contained shall prohibit the executor or administrator from redeeming the property mortgaged or pledged by paying the debt for which it is held as security under the direction of the court, if the court shall adjudge it to be for the best interest of the estate that such redemption shall be made. Rule 86, Section 8. Claim of executor or administrator against an estate. If the executor or administrator has a claim against the estate he represents, he shall give notice thereof in writing to the court, and the court shall appoint a special administrator, who shall in the adjustment of such claim have the same power and be subject to the same liability as the general administrator or executor in the settlement of other claims. The court may order the executor or administrator to pay to the special administrator necessary funds to defend such claim. Rule 86, Section 9. How to file a claim, contents thereof, notice to executor or administrator. A claim may be filed by delivering the same with the necessary vouchers to the clerk of court and by serving a copy thereof on the executor or administrator. If the claim be founded on a bond, bill, note, or any other instrument, the original need not be filed, but a copy thereof with all endorsements shall be attached to the claim and filed therewith. On demand, however, of the executor or administrator, or by order of the court or judge, the original shall be exhibited, unless it be lost or destroyed, in which case the claimant must accompany his claim with an affidavit or affidavits containing a copy or particular description of the instrument and stating its loss or destruction. When the claim is due, it must be supported by affidavit stating the amount justly due, that no payments have been made thereon which are not credited, and that there are no offsets to the same to the knowledge of the affiant. If the claim is not due or is contingent, when filed, it must also be supported by an affidavit stating the particulars thereof. When the affidavit is made by a person other than the claimant, he must set forth therein the reason why it is not made by the claimant. The claim once filed shall be attached to the record of the case, in which the letters testamentary or of administration were issued, although the court in its discretion and as a matter of convenience may order all the claims to be collected in a separate folder. Rule 86, Section 10. answer of executor or administrator offsets. Within 15 days after service of a copy of the claim on the executor or administrator, he shall file his answer admitting or denying the claim specifically and setting forth the substance of the matters which are relied upon to support the admission or denial. If he has no knowledge sufficient to enable him to admit or deny specifically, he shall state such want of knowledge. The executor or administrator in his answer shall allege in offset any claim which the decedent before death had against the claimant, and his failure to do so shall bar the claim forever. A copy of the answer shall be served by the executor or administrator on the claimant. The court, in its discretion, may extend the time for filing such an answer. Rule 86, Section 11, Disposition of Admitted Claim. Any claim admitted entirely by the executor or administrator shall immediately be submitted by the clerk to the court, who may approve the same without hearing. But the court, in its discretion, before approving the claim, may order that the known heirs, legatees, or devisees be notified and heard. If upon hearing an heir, legatee, or devisee opposes the claim, the court may, in its discretion, allow him 15 days to file an answer to the claim in the manner prescribed in the preceding section. Rule 86, Section 12, Trial of Contested Claim. Upon the filing of an answer to a claim, or upon the expiration of the time for such filing, the clerk of court shall set the claim for trial with notice to both parties. The court may refer the claim to a commissioner. Rule 86, Section 13, Judgment Appealable. The judgment of the court approving or disapproving a claim shall be filed with a record of the administration proceedings with notice to both parties and is appealable as an ordinary case. A judgment against the executor or administrator shall be that he pay in due course of administration the amount ascertained to be due, and it shall not create any lien upon the property of the estate or give to the judgment creditor any priority of payment. Rule 86, Section 14, Costs. When the executor or administrator, in his answer, admits and offers to pay any part of a claim, and the claimant refuses to accept the amount offered in satisfaction of his claim, if he fails to obtain a more favorable judgment, he cannot recover costs, but he must pay to the executor or administrator costs from the time of the offer. Where an action commenced against the deceased for money has been discontinued, and the claim embraced therein presented as in this rule, provided the prevailing party shall be allowed the costs of his action up to the time of its discontinuance.